Well, hello. Welcome to the video segment for the legal environment of business. The video segment dealing with negligence and strict liability. Now, if you looked at the previous video, that was for intentional torts. And we talked about the fact that there are two types of torts. One type is intentional torts, and the other type is unintentional torts. And when we speak about that, we're just talking about torts based in negligence, and also possibly strict liability torts and strict products liability torts. By way of review, a tort is a civil wrong as opposed to a criminal act. You can have assault and battery as a criminal act, but you can also have in the civil arena assault and battery as a civil wrong that you sue for in tort and you receive damages for your injuries sustained. They hold people responsible for how they act and how they use the property. See, we have this belief in society that people should be secure in themselves and their possessions. We have the right to be left alone and not to be bothered by other people, either intentionally or unintentionally. So we've got these different types of torts: intentional torts, unintentional torts, again, based upon negligence and strict liability. Let's analyze the tort. When you look at a tort, as I said in the previous video segment, you got to take it frame by frame to see what actions are going on here to make sure you've got all the necessary elements of a tort, because when it goes before a jury, they're going to do the same thing in order to make a factual determination as to whether or not all the necessary elements of a tort, whether it's an intentional tort or an unintentional tort, whether all of those elements are present, and hopefully they will, and render a jury verdict in your favor. And before we talk about unintentional torts, sometimes I get asked by students, Bollinger, why are we talking about torts in business law? What does that have to do with business law? Well, you're probably going to find out in your business that at one time or another, there may be a lawsuit filed against your business for maybe an act of violence in the workplace by one person against another person. You'll have an intentional tort there, or what is even more possible, some type of act of negligence that occurred as a result of a slip and fall on your business premises where somebody is hurt and your business might get sued for negligence. Or even worse, if you manufacture or distribute or sell some type of product and that product proves to be defective, your business could be a defendant in a strict products liability suit. So there's the relevance. That's why we talk about torts. And with that overall introduction, let's move on with, let's talk about intentional torts again, review. You've got the deliberate action that causes injury as opposed to unintentional torts based upon negligence. Let's look at those elements. You've got in negligence a situation in which the defendant owed a duty of care to the plaintiff. That's the first element. Second, the defendant breached that duty of care to the plaintiff. Number three, the plaintiff suffered some type of injury. And then number four, the defendant's negligent act caused the injury. And you have to have two types of causation. One is factual causation, which is known as but-for causation, and the other is legal causation, also known as proximate cause, which is based on foreseeability. Now, your eyes all just glazed over at this point. I realize that. We're going to break all those down and talk about those right now, but bear in mind, each one of those elements have to be present for the plaintiff's suit to successfully prove up a negligence lawsuit. All right, let's start off with the duty of care. If there's no duty of care, if there's no duty to another person, you do not owe that person a duty of reasonable care. So in some situations, there's no duty exists. Other situations, a duty does exist. The duty arises out of the person's conduct or activity. You have no duty arising through any type of non-conduct or lack of relation, but that duty can arise once you spring into action and create that relation. Let's use an example. A person could be drowning in the ocean in 1 inch of water. 1 inch of water. You walk by, or they could be drowning and flailing in deep water. You walk by, you have no duty under the law to help that person, I guess, unless you're a lifeguard. Let's say you're not a lifeguard. You're walking along the beach, you see the person drowning. You have no duty to help that person. There might be a moral duty there, but that does not make you legally responsible or legally required to go out there and rescue that person. However, the second you jump in the water and swim towards that person and make contact with them, you have created a duty. You have established a relation. So if anything happens to that person, as a result of you trying to help them and rescue them, you could be found responsible or negligent as a result of the breach of your duty of due care, which is why you see in so many situations people saying, oh, I don't want to get involved, which is kind of sad. Well, what type of duties do we have? Well, some are automatic, like lifeguards and merchants on premises. If a person comes in your place of business, you have a duty to make sure that they're safe. And a safe home for your guests as well. Some duties are assumed by the defendant when they choose to undertake action, like the person who went out to rescue the person drowning in water. There are some Good Samaritan laws that are out there that protect certain professionals like doctors and nurses if they go out and they help somebody who's injured on the side of the road and something bad happens, because we want to encourage that type of behavior. So you've got this duty of care, then the breach of duty. The behavior that results in the person being injured as a result of you breaching that duty of care, the slip and fall on your premises, your business premises, the person falling down and hurting themselves at your place of residence, injuring the person as you're helping to rescue them, or some type of willful and wanton negligent act. You get in behind the wheel of your car after getting totally drunk, and you injure somebody as a result of your drunken driving. That is also criminal negligence as well as civil wanton and willful negligence. So you've got that breach of duty. Well, let's move on to causation. You got to show causation in fact that but for this event, this wouldn't have happened. Well, the bar is pretty low with but for causation. But with regard to proximate cause, that's based upon foreseeability. Was it foreseeable that this action would lead to this injury and damage to the person? The bar is a little bit higher when it comes to proximate cause, and we will explore that further in class. So we've got causation in fact, the but-for test. You've got proximate cause based upon foreseeability. And is it foreseeable that this event leads to the injuries sustained by the person? Proximate cause, the seminal case in that is the Palsgraf case. We'll talk about that in class. And we'll also talk about the McDonald's case that is covered in the textbook, the 1984 McDonald's case that took place down in National City involving a mass shooting involving Mr. James Huberty, who was the person who went into the McDonald's and pulled the trigger and tragically killed several people. Now, there's going to be some defenses in negligence, contributory negligence. What you did contributed to the accident. You were flailing around when I was trying to rescue you, so you contributed to your injuries. Or you assumed the risk. If you go to the baseball game and sit along the third baseline and you're hit by a foul ball, the baseball team could assert the defense of assumption of the risk. And there are other defenses that we'll cover as well. Contributory negligence is another defense. What you did contributed to it. There's also comparative negligence. Traditional contributory negligence means if you were contributed at all to the negligence, you're barred from recovery. Comparative negligence takes into more of account a percentage approach, and if you contributed 10% to the problem of me trying to rescue you, I'm only 90% responsible, so you only get a 90% recovery from me. Any other defenses against negligence? Assumption of the risk. We talked about that. They assumed the risk. Let's look at strict liability. That can occur with products. That occurs when there's a production defect, and we'll speak about that, versus a design defect, two different types of defect. And that's where the Ford Pinto case comes in, that's in your textbook. Also, strict liability can occur in ultra-hazardous types of activities. holding on or retaining wild animals, or working in a factory where there's explosives or fireworks. No matter how careful you are, no matter how diligent you are in maintaining a safe environment, if something bad happens because you're engaged in ultra hazardous activity, you will be found strictly liable in tort. Then there's also product liability. Where you have manufacturers that could be liable, distributors could be liable, retailers could be liable, entities that are involved in the chain of commerce that may be selling, manufacturing, or distributing defective products. They all could be potential defendants. Well, who could be plaintiffs? No privity of contract is required. If I buy a defective weed whacker, take it in my garage, open it up, and while I'm doing that, my nosy neighbor comes over and I crank up that weed whacker and it blows up, injuring both myself and my neighbor, even though my neighbor has no privity of contract, even though he did not buy the weed whacker, he could too be a plaintiff in that action. Covers family members, guests, employees, and so forth. As I indicated in the previous segment, damages can include compensatory damages, which include special damages, the cost of my hospital bills, my lost wages, and so forth, and also what are known as general damages, damages that could be emotional distress, pain and suffering, a little bit more amorphous in how they're calculated, and also punitive damages that send a message to society that that type of behavior will not be tolerated. We see punitive damages in tort cases. We rarely see them in contract cases, but they do exist, and we'll talk about that in contracts. Well, that pretty well sums it up for unintentional torts. So we'll wrap up this video, and we'll see you at the next video segment. Take care, have a good day, and be safe.